Filing. Special Counsel Jack Smith has made multiple major filings in the federal criminal case against Donald Trump in the federal court for the Southern District of Florida this week. Popok, have you ever seen this many filings in a case like this done so quickly? Special Counsel Jack Smith is pushing for a 2023 trial date. He has already confirmed to the court that his team has turned over mostly all non-classified records to Trump's legal team and that they went above and beyond their discovery obligations at this point. This is some of the most efficient, I would say the most efficient Department of Justice work I have ever seen. And Special Counsel Jack Smith has also made another filing where he notes that he has at least, get this, 84 witnesses against Donald Trump. 84 witnesses. But Jack Smith is not stopping there. Jack don't stop. This week, we saw major developments in Special Counsel Jack Smith's other criminal case, his other criminal investigation into Donald Trump's election interference. More witnesses went before the criminal grand jury in Washington, D.C. that is investigating Trump's 2020 election interference. And we've learned that Jack Smith may be closer to entering into a proffer agreement. Don't worry, we'll explain what that means with the head of Donald Trump's election day operations, the individual who led Trump's criminal fake elector scheme, who's ready, apparently, to spill the dirt. Trump's top people are flipping. Sanctions incoming. Rudy Giuliani has been sanctioned by a federal judge in Washington, D.C., the famous Judge Beryl Howell, for discovery abuses in the defamation case filed against him by Georgia election workers Ruby Freeman and Shay Moss. The federal judge Beryl Howell had enough of his games, and she brought down the Beryl Hammer, the Beryl Howell Hammer, and I'm such a geek, and the Donald Trump's lawyers keep making humiliating filings in the Jean Carroll case, where a jury awarded Jean Carroll $5 million, including essentially admitting that Trump couldn't secure a bond for his appeal, so he wants to deposit cash that's currently being held in Joe Tacopina's client trust account. We will break this all down on this episode of Legal AF. I'm Ben Meiselas, joined by Michael Popok. A lot going on, but you think about where we were last week, where we are today. Special Counsel Jack Smith is basically the fighter jet pilot of prosecutors. He's saying, let's go.
Well, this starts from you're right, Ben. This starts from the very beginning. Day one of him being appointed 7 months ago, he issued 4 subpoenas. You and I, we did hot takes on that then. It was like, wow, he's really ready to go. Right. He is ready to go. Look what he's accomplished, in 7 months. More importantly, for this particular case, and we're going to talk about it in the podcast a little later on, Jack Smith's not done. And now that he's got the indictment under his belt, he's going to use a new weapon in his arsenal against other witnesses in his other prosecutions, and that's fear. That's fear in Trump world, because it's no longer what if he indicts, it's he's already indicted in Mar-a-Lago, and he's coming to you next because he's not done. This is the destroyer of all Trump world, Jack Smith. And so we weren't surprised, you and me, and our audience shouldn't be either because of the way we've been reporting and analyzing up until now, that Jack Smith's team was waiting until they had not just the ability to obtain an indictment from the grand jury for all things Mar-a-Lago, but were ready for trial. That's why a lot of us were saying, some people were saying, well, why just indict? He can, a good prosecutor can indict a ham sandwich. That's an old joke. Right. But a federal prosecutor that is careful and conscientious like Jack Smith doesn't want to do it until he knows he has every witness, every document, every video, every audio, every piece of evidence ready, so that in case there's no waiver of the Speedy Trial Act, or there's not other issues you and I will talk about on the podcast, he's ready to go within 70 or 150 days to try a case. And that's what we're seeing right on the heels 2 days ago of Jack Smith doing a data dump of all non-classified evidence to Donald Trump. Everything except for the classified stuff, which is in a separate category. He produced in record time one big package, which demonstrates to the world, the judge and the opposing counsel and Donald Trump, that the prosecution is loaded for bear on this trial. So when he produced all this stuff, Ben, he said effectively, there are 3 parts to our production. We're giving you all the documents obtained by subpoena of any party, all witnesses in this case, and defense. You're getting them here now. We're giving you what we got from search warrants. We'll give you all the grand jury transcripts, both of the District of Columbia and the Southern District of Florida. We'll give you our witness interview notes. Then we have a separate batch of hot docs. We'll give you our key docs of all the photographs and documentation. And by the way, we have closed circuit television video cameras, which is I'm sure the Trump Organization video feeds for outside the storage rooms and other spots at Mar-a-Lago, and we'll give you those, and we'll tell you where in the video you can find the incriminating evidence. But we're not done. We will give, it's like a late night sales show. They're going to be selling knives and juicers soon. We'll also give you all of the classified evidence as soon as you get your security clearance. And we're going to put you on fast track for that. We'll get you your security clearance within 40 days or so. So you'll get all of that. And then you can come over and you can inspect everything that's not classified that we pulled out of Mar-a-Lago with a special inspection. You can do all that. We'll give you Walt Nauda's FBI investigation notes, interview notes. We'll give you his grand jury transcript that shows basically that he lied. We'll give you public statements by Donald Trump that we're relying on, and we'll give you other statements recorded of Donald Trump by other people. Hint, hint, Margot Marks, your assistant. We'll give you that too. And then you'll get the classifieds. And that is that was done 2 days ago. You and I were like, holy schmagoli. Look at the amount of stuff, basically almost their entire trial file, they're turning over right now. Why? Because 2 days later, they were going to file the motion for continuance and ask, yes, for a continuance, but a very short continuance. Right in the ballpark that you and I talked about in past, and I talked about with Karen, Ben. I said end of the year, first quarter. He's going right around my birthday, December the 13th or the 14th. And he's saying, yeah, that would be appropriate. That gives the defense time to get all their security issues resolved for the classified documents. It gives us time to get prepared. It gives the public time, because people forget the speedy trial statute, which is what everybody's been relying on to set this thing 70 days out, is not just for the defendant to get to trials in a speedy fashion. It's for the there's a public component to it, that the public had confidence in our justice system and that people go to trial quickly, as opposed to in dictatorships where people go to trial, years later. We have a reporter for the Wall Street Journal who's sitting in a Russian prison who just got extended another 12 weeks of pre-hearing detention. We don't do that here. We try to get to trial quickly. Now the ball is back in the court for the defense, for Todd Blanche and Chris Kice for Donald Trump to file their own paper, which they're going to because it was anticipated in the filing, opposing the date, not the continuance, the date. They don't like December. Of course, they want to put it like after the primaries, maybe after the election, some other time. But now you have the push-pull. Judge set the marker of August. DOJ says, August won't work, Judge. How about December? And now you're going to have the push-pull as the defense rolls in, files their opposition papers. The other fascinating thing, Ben, was what you said is the earlier filing, also 2 days ago, in which, for people to remember, the magistrate judge who arraigned Donald Trump, Magistrate Goodman in Miami, set a special condition. He actually set a special condition for release of Donald Trump that the DOJ didn't even ask for. But he said, I'm not going to let him talk to witnesses without lawyers present, including the one that works for him right now, Walt Nauta. So I'm imposing that special condition, and I want the Department of Justice to develop a list on their own, and that's the list of witnesses that will not be contacted by Donald Trump by name at all. And now the Department of Justice has 84 names, as you said, Ben, and they dropped a footnote and said, that's not all. We have more witnesses potentially at trial, but these are the hot 84 we don't want Donald Trump to talk to without a lawyer to try to influence their testimony. And they're prepared to give those names to the defense and give them to the magistrate judge, but they want to do it under seal, meaning they don't want all those names revealed at the present time. So that issue of whether that sealing is going to happen is going to be in front of, I would suspect, Goodman again, although it could go back to Judge Reinhart, the magistrate judge. I don't think it's a canon issue. I think it's a magistrate judge issue, which will be decided between one of those two magistrate judges. The other side's probably going to be like, 84 is too big. That's too many people. We want to be able to talk to witnesses. There'll be a fight over the number that are on the list. And then there'll be a fight over the ceiling, although I'm not sure Donald Trump really wants all the names revealed of all these people. So I want to hear your opinion, Ben, as to whether he fights over sealing versus not sealing this amount. But if anybody, the takeaway from these three filings for me is they're ready to try this case like now. If it wasn't for the classified documents issue that needs more time for the defense to get their security clearance, Jack Smith and his team, the lead lawyers there, are ready to go to trial and say, ready, pick a jury. And of course, the defense is not.
All right. So first, addressing whether I think Donald Trump's lawyers are going to object to the sealing of the names. I don't think they care about the actual sealing of the witness names. I think they care about the list, and they're going to object to the fact that they claim that that Donald Trump should be able to have conversations with his criminal co-conspirators without having to go through lawyers as intermediaries, and that restriction shouldn't apply to all 84 people. But and the reason why I say that is if you go to footnote 2 in the filing, government's motion to implement special condition of release, it says the following, footnote 2, the government has conferred with counsel for defendant Trump and defendant Nauta about this motion. They have authorized the government's counsel to represent the following. Defense, meaning Trump and Nauta, take no position on the government's motion to seal the list of witnesses, but the defense reserves the right to object to the special condition and the manner in which it is implemented by the government by providing a list of 84 witnesses in purported compliance with. And then we'll talk about Judge Goodman's order. So they don't have an issue with it being filed under seal. They're not going to object to that. But the conditions imposed by Judge Goodman that Trump can't have any communications with witnesses directly about the case. He can have communications with the witnesses, just not about the case. If it's about the case, it has to go through lawyers. We can see a situation where Trump's lawyers object to that. But let's break down a lot of the things that you said there, Popok. First off, your use of the term holy schmagoli. Want to give you credit for that. That's not a legal term out there for anybody wondering. I'm more of a holy schmoly guy, but you kind of went schmagoli. So I'm good with that. I'm good with that. Second, when it comes to the discovery dump, and Donald Trump loves dumps. Actually, he hates dumps. He must hate, because that's what he always talks about. But he certainly will hate this document dump right here by Special Counsel Jack Smith. When Jack Smith went above and beyond what his discovery obligations are. And you mentioned the categories of documents. We're talking about, the grand jury testimony and witness statements that were done outside the presence of grand jury, witness list, photographs, CCTV surveillance footage, essentially all the non-classified documents in the possession and custody and control of Special Counsel Jack Smith's team was turned over to Donald Trump's lawyers. And the timing of it, though, just to give everybody perspective, This is stuff that is eventually turned over by the Department of Justice, but oftentimes the Department of Justice in cases will wait to turn stuff over. Like on the eve of trial, they'll turn it over in different kind of tranches of documents. Here, Special Counsel Jack Smith just turned everything over right away, basically signaling, hey, we are ready to go. Also, Special Counsel Jack Smith's team essentially dummy-proofed it for Donald Trump. And you alluded to this in what you were saying, which is Jack Smith flagged for Donald Trump's lawyers the key portions that the government is going to use at trial already, and saying, look, we'll give you all the surveillance footage, but we understand it's a lot. Jack Smith doesn't say this, but we get that, your crew isn't the brightest, and you're going to claim that it's going to take you a long time to look through these records. Well, we've done the work for you. So we've actually summarized kind of minute by minute what goes down in these videos, the key portions. If you don't trust us, you can go through it yourself, but we're not going to deviate for purposes of the trial on the portions that we intend to use, and we're going to share that with you right away. So dummy proofing it right away. And speaking about kind of dummy proofing it right away, I also think Special Counsel Jack Smith's team learned a lot of lessons from how Judge Eileen Cannon handled her docket, or rather I should say mishandled her docket the last time around, where Donald Trump initiated the Trump v. United States case, and Judge Eileen Cannon improperly, unlawfully asserted jurisdiction, didn't know what she was doing, was overturned in a very strongly worded opinion by the 11th Circuit Court of Appeals twice. So to me, a lot of these filings that are being made, really four major ones that were filed this week, the one that you mentioned, giving notice to Judge Eileen Cannon that all of these documents were turned over, and then these three others that I'm about to talk about, they're also educating Judge Eileen Cannon on what to do. And that scene from I wish I remembered the movie, but everyone will say it in the comments.
Tell me the movie.
Where
Tell
the
me
person
the scene.
takes over the ship, and again he goes, it's my ship now. It's my, this is my ship now. That's kind of what Special Counsel Jack Smith is doing here. He's saying, this is my court. You may be the judge, Judge Eileen Cannon, but let me explain to you how we do things in Classified Information Procedure Act cases.
Crimson Tide, Gene Hackman and Denzel Washington.
No. It's the Tom Hanks movie with Saving Captain Phillips. Saving Captain Phillips.
Salty
Captain
saved
Phillips.
the day. I didn't know which boat
Captain
we were
Phillips,
talking
it's
about.
my ship now, or the line is something like that. But that's what Special Counsel Jack Smith is saying here. And a lot of people may have heard, well, Special Counsel Jack Smith requested a continuance. Popok. Ben, what are you talking about here? Why is he continuing the date? That's not aggressive. Well, as Michael Popok alluded to at the outset, the date that was set by Judge Eileen Cannon, well, you all know this from watching Legal AF and our hot takes, because we explain this when the trial date is set, unlike other programs that may not actually explain what these things are. Under the Speedy Trial Act, it's a federal law which interprets the Sixth Amendment of the Constitution that gives a criminal defendant the right to a speedy trial, among other important rights that take place in a criminal trial. You have to set it within 70 days of the first appearance. But that doesn't mean that's going to be the date, because if you look at paragraph 10 in Judge Eileen Cannon's omnibus order that set the trial date for August 14th of 2023, it talks about continuances in a SIPA case, a Classified Information Procedures Act case. And we had all discussed here on the show that Donald Trump's lawyers were going to be filing motions saying they needed more time. They're going to file motions to dismiss. They're going to be doing all of these things, that they don't have the discovery. They don't have all of these things. So Special Counsel Jack Smith needed to get ahead of that. So that's what this was. When Special Counsel Jack Smith filed this motion, again, I'll go through the three motions, and this one's called the Government's Motion for Continuance and Proposed Revised Scheduling Order. Here it is right there for those watching on YouTube. We're posting the document, and says, for the reasons discussed below, the government files this motion to continue the trial date to December 11th, 2023, and then to propose associated deadlines. What Special Counsel Jack Smith is saying is that is the hard and fast day. That's the day we're ready to go. We want trial in 2023. And we know that Donald Trump's lawyers are going to object to that. And how do we know that they're going to object to that? Well, it says it. Defense counsel confirmed they do not, it's in that same paragraph. Defense counsel confirmed they do not oppose an adjournment of the current trial date and request a status hearing with the court to address the schedule in this action. Defense counsel anticipate filing an opposition to this motion, addressing their objection to the government's proposed date. So what that means is what we've been saying all along, right? That what Trump is going to request, this is what Popok said before, what Trump is going to say is, we need, this is my prediction, he hasn't filed this yet, but I can almost say with 99% certainty, and Popok, correct me if you think I'm wrong here, that he wants to have trial within 90 days after the 2024 election, or even thereafter. He may even say, we want to have a status conference after the 2024 election, and let's hold a trial setting conference that not even set the trial date then. But his big play here is to kick this trial after 2024. And that's going to be the major decision that we hear from Judge Eileen Cannon. Is she going to kick this thing and buy those arguments until after the 2024 election? Or is she going to follow here Special Counsel Jack Smith saying December 11th of 2023? Or is Special Counsel Jack Smith here even posturing a little bit, saying, okay, if I say December 11, 2023, Trump says after 2024, there's a compromise date, and that puts it more like in early 2024. So that's what Special Counsel Jack Smith is doing here. The two other motions that were filed, one's called the government's motion to implement special conditions of release, and the other one's called the government motion for a pretrial conference pursuant to the Classified Information Procedures Act and appointment of a classified information security officer. Popok hit both of these. I just wanted to show you their official titles there. The government's motion to implement the special conditions of release, as Michael Popok mentioned, that addresses Magistrate Judge Goodman's special condition that Donald Trump couldn't speak to the witnesses directly, and the government wants to make clear, here are the 84 witnesses that are subject to that special condition. I think this will go before Judge Reinhart, not Judge Goodman. I think Judge Goodman was just the duty judge for that day. So I think Reinhart will ultimately hear this. And then there's the government's motion for a pretrial conference. And this is Special Counsel Jack Smith just saying, Judge, we are ready to go. Let's set a trial. Let me educate you on the Classified Information Procedures Act. And that's essentially what it says is we need to have a hearing. Let's go through the steps. Let's go through the security clearance process. But really, as I said, it's Jack Smith saying to Judge Eileen Cannon, we got this. Follow along, and you're not going to look humiliated again. And to tie a neat bow around this, the weakness of Donald Trump, the weakness of what's going on with these MAGA Republicans right now, I also think it's not coincidental that we see what's going on in Russia right now is very much linked, because those forces, the MAGA Republican forces and Putin's kind of forces, that whole propaganda base is very much inextricably intertwined. I want to talk more about Special Counsel Jack Smith's other criminal investigation regarding Donald Trump's election interference, why I think Donald Trump's never been weaker and more vulnerable than he is right now. And Popok, to your point, how Special Counsel Jack Smith has just scared the crap and shock and awe fashion in anybody in Trump's world. I want to get all your take on that, but first, let's take a quick break.
Oh, hey, I didn't see you there. Look, everyone knows how annoying cheap razors are. The cuts, the irritation, the frustration. And don't get me started with subscription razor services, the headaches that those can cause. That's why you gotta meet Henson Shaving. Henson Shaving is a family-owned aerospace parts manufacturer that has made parts for the ISS. That's the International Space Station and Mars rover. And now they're bringing precision engineering to your shaving experience. Razor blades, they're like diving boards. The longer the board, the more wobble. The more wobble, the more nicks, cuts, and scrapes. A bad shave, it isn't a blade problem. It's an extension problem. By using aerospace-grade CNC machines, Henson makes metal razors that extend just 0.0013 inches, which is less than the thickness of human hair. That means a secure and stable blade with a vibration-free shave. It gets better. The razor has built-in channels to evacuate hair and cream, which makes clogging virtually impossible. Seriously, Henson Shaving wants the best razor, not the best razor business. That means no plastic, no subscriptions, no proprietary blades, and no planned obsolescence. The Henson razor works with standard dual-edge blades to give you that old-school shave with the benefits of new-school tech. Once you own a Henson razor, it's only about $3 to $5 per year to replace the blades. My first shave with the Henson razor was incredibly refreshing. The design is sleek and the durability is top-notch. The Henson razor is truly so much better than your run-of-the-mill quote-unquote traditional razor brand. And the affordability factor is absolutely game-changing. No more wasting your money on expensive blades. With Henson Shaving, you can get a year of blades for just $5. Okay, so this is what you have to do. It's time to say no to subscriptions and yes to a razor that'll last you a lifetime. Visit hensonshaving.com/legalaf to pick up the razor for you and use our code LEGALAF and you'll get 2 years worth of blades free with your razor. Just make sure to add them to your cart. That's 100 free blades when you head to hensonshaving.com/legalaf and use code LEGALAF. And now back to the video.
Thanks, Jordy. Always a highlight of the show for me to see Jordy doing those ads. And for everybody wondering how you can get these Legal AF emojis on YouTube and the Jack Smith emojis on YouTube, what you got to do is on the bottom of the YouTube chat, there's that $. You could purchase memberships in the MeidasTouch YouTube channel, and that enables the use of emojis. And if you're already a member, you can buy memberships for other people. And then you could ask to receive a gift if you want to be on the receiving end of the membership gifts right there. So that's how you do that. And go to store.meidastouch.com for those convict or convict 45 pins. Jordy always wants me to mention that. I really like those pins. And we got a bunch of other great Legal AF gear as well. So Michael Popok, we've got a lot of action as well going on in the grand jury in Washington, D.C. Special Counsel Jack Smith can, I guess the expression, walk and chew gum at the same time. He could be prosecuting a traitor in the Southern District of Florida while criminally investigating the traitor in Washington, D.C. What's up? What do we know that's going on?
Yeah. Before I get there, I want to wrap up something in our prior, which will lead into this segment. The other thing that I found amazing is Jack Smith telling the judge, Judge Cannon, in terms of scheduling, that this is not a complicated case at all. In fact, if we look back at that quote, he said in his filing, in his motion for continuance, that this case is not unusual or complex. It's not novel. It doesn't have any novel law questions. It's straightforward on theories of liability, and it only has 2 defendants. Now, you know the other side's going to say, this is historical. This is the first time, Presidential Records Act, Espionage Act. Not to Jack Smith. To Jack Smith, this is the run-of-the-mill garden variety. Somebody stole, used, didn't return government NDI, National Defense Information, and should be prosecuted for it. It's not novel. It's straightforward. It involves 2 defendants, and we don't need a lot more time to prepare. And if it wasn't for the security issues, Your Honor, we'd be ready to try the case right now. That strength, that power, that muscularity is now what he brings forward when he looks witnesses in the eye. His team looks witnesses in the eye and says, you either testify, cooperate to the grand jury, or go look what just happened to other people in your orbit on the Mar-a-Lago matter. You think we're screwing around? We're not screwing around. That gives the prosecution an extra special sense of power and another arrow in their quill that they can use against people. We rarely have a situation where a prosecutor like Jack Smith has multiple grand juries and multiple separate, sometimes connected investigations of one person and those around him. That's rare. Usually it's one grand jury and we have one indictment. It might be an omnibus indictment that covers a lot of different ground, but we rarely have that. And Jack Smith is using that to his advantage, right? He's using the pressure that builds. So now when he reaches somebody like Michael Roman and G. Michael Brown, who were the two lead henchmen for Donald Trump, John Eastman, Peter Navarro, and Rudy Giuliani and Jenna Ellis to implement the fake elector scheme. He's not the architect of it, but those two guys as the director of election day operations for the Trump team and the deputy director of election day operations, they're now getting, for those that are watching it on YouTube, getting squeezed. There's lower regions of their body that are now in a vice, and they're getting squeezed because what they once were able to do, which was to flout and thumb their nose at the Jan 6 committee and not cooperate there, they can't do it with a prosecutor that has a taste for blood, okay, that already has indicted Donald Trump, their former boss. So all they got to do is say, hey, remember when you were playing games with us about the terms on which you would cooperate? Why don't you go check what's going down at Mar-a-Lago? You're next. And I'm sure they haven't said exactly that, but they might have said exactly that in negotiations, because now all the little rabbits are running scared because they got to cut a deal. Otherwise, they're going to go down like their boss. They're going, holy cow, or holy shmagoli, which seems to be a theme for today. They just got, my boss, Trump just got indicted. What, me? I got no shot at avoiding indictment. And that's what they're telling them. So now Michael Roman, it's remarkable that he is the highest level of person on the fake elector scandal or scheme to cooperate with the government. There is reporting that he is working out a proffer deal for immunity. Could be what we call queen for the day immunity, meaning you come in and whatever you say that day, as long as it's truthful, you don't lie to the government in putting your statement on the record, which it'll be on the record under oath. We won't use that against you in prosecuting you. We haven't decided whether we're going to prosecute you yet, but we won't use your own words against you. If we independently develop that information, fine. That's queen for the day. Or they give a full immunity because they just are like salivating the prosecutors that they got the highest level person along with his other henchman, G. Michael Brown, who ran around and actually delivered the fake electors' ballots, if you will, to Congress, who were coordinating. There was one state, I don't remember which one exactly, because there were 7 states that they were trying to use the scheme of having phony electors certify that they were for Trump, not Biden, and then have, of course, for this scheme to work, Mike Pence, sitting there as the president of the Senate, had to recognize these ballots or have one of the crazy Congress people, the MAGA Congress people or senators, jump up and say, oh, there's other ballots that need to be evaluated. We need to delay and recognize them. And then Mike Pence was supposed to, if he's following the script, which he wasn't, he would have said, well, you're right. I think we need to throw this over to the House to investigate or to vote for the president. Use that instead of the delegates, which would have led to a Trump victory, because if you do it by House vote, most of the state delegations are Republican in those kind of numbers. So that would have been terrible. But that was the plan. John Eastman helped develop it, the absent-minded professor who came up with all these crazy legal schemes and theories, was about to lose his law license. Peter Navarro involved. Jenna Ellis, Rudy Giuliani there with Sidney Powell to implement it. Lawyers around the country, the battleground states, joined forces with these people. But the coordinator on the ground, Michael Roman and G. Michael Brown. And if Michael Roman is cooperating, that spells disaster for Donald Trump. He's now brought in, Ben, Jack Smith's brought into the fake electors grand jury in the last week alone, 6 witnesses, including cooperating witnesses and those he's given some level of immunity, including the 2 highest level GOP officials in Nevada, the head of the GOP in Nevada, and his assistant have both been given limited immunity to testify. Michael McDonald and another guy whose name I always butcher. So for those that think, oh, he must be done, his lust for convictions is over, Mar-a-Lago is enough for Jack Smith. It's not. It's not. The next is fake electors. Then it's going to be the Jan 6th and what happened on that day in the Willard Hotel and otherwise. And then it's going to be the grift, which is the money that was raised on the backs of the lie by Donald Trump and put into his PAC coffers and all of that. And all of that is still going on. But now with a new superpower for Jack Smith, which is, you see what just happened to the guy next to you? That's happening to you next. Get into that box and testify for the government or cooperate with us. And now they're all scurrying to do that.
Whether you want to call it a crescendo or a coda, or you pick the term, but it's kind of like the end of a fireworks show, right? When you think about the proceedings before the grand jury. And we saw this happen with the grand jury that was investigating Trump for the willful retention of national defense information, right? There was this huge flurry of activity, and then there was a quiet period for 20 days, an eerie quiet period. And what did we say was happening during that time period? We said, well, what's happening is Special Counsel Jack Smith is now writing the charging memoranda to be sent to Attorney General Merrick Garland, because ultimately Merrick Garland is going to have to approve the decision to prosecute. As we said, when it came to the willful retention of national defense information and obstruction of justice, we said that we strongly believe Merrick Garland was going to approve it. Merrick Garland did approve it. And the rest is history there. So I think we're seeing something similar happen right here in the investigation of election interference by Special Counsel Jack Smith. You mentioned the Willard Hotel, the 5-star, beautiful hotel in Washington, D.C. that only MAGA could freaking defile and turn into basically their war room for overthrowing our democracy. But that's what the Willard Hotel turned into. Willard Hotel is steps away from the White House. It's right there in Washington, D.C., right around all of the government buildings. And that was used by people like Roger Stone and Mike Flynn, and I think Alex Jones was there, and you had this whole group. Mark Meadows wanted to be there. Giuliani was there. You remember Mark Meadows told Cassidy Hutchinson that he wanted to go. And in Cassidy Hutchinson's testimony before the January 6th committee, she basically said, what are you doing? Don't go there. And apparently Mark Meadows called in and didn't actually go to the Willard Hotel itself. But why I'm mentioning the Willard Hotel is that there was another development this week that's a little bit more under the radar, but I think very important. A host for one of Alex Jones's shows, InfoWars, somebody by the name of Owen Schroyer, agreed to a cooperation agreement, agreed to plead guilty for his involvement in the January 6th insurrection, and also agreed to cooperate with the Department of Justice. Why is Owen Schroyer's cooperation agreement and guilty plea important? Well, first off, if you go into the cooperation agreement, it says cooperation with additional investigation. Owen Schroyer, your client, agrees to allow law enforcement agents to review any social media accounts operated by your client for statements and postings in and around January 6, 2021, prior to sentencing. And Owen Schroyer was at the Willard Hotel. He was in those rooms with Stone and Flynn and Alex Jones and Giuliani and all the Trump advisors as well, who was in that room. So to get Schroyer to explain what was going down inside the Willard Hotel, at the same time, we now have Michael Roman talking about the fake elector scheme. I think that is all very much related. And just to remind everybody the various aspects of this investigation by Special Counsel Jack Smith into election interference, I like to characterize it or categorize it into 4 categories. The first is like the day of the insurrection itself. And I think of the crimes of obstructing an official proceeding and seditious conspiracy. Based on how Special Counsel Jack Smith charged Donald Trump in the theft of the classified records, I would not be shocked if we even saw a seditious conspiracy charge being brought against Donald Trump. But I think we will definitely see an obstruction of official proceeding charge. And also there's kind of been proxy wars, if you will, being fought by the Department of Justice and agents of Donald Trump in other criminal cases where the Department of Justice has successfully prosecuted people under the obstruction of official proceeding. And you may recall from some of our prior reporting, for example, that a Trump-appointed judge, Judge Carl Nichols, in a case involving very vile insurrectionists, had made a ruling that obstruction of an official proceeding did not apply to those insurrectionists unless they physically like ripped up documents and shredded documents. And Judge Carl Nichols took a very restrictive view of the statute, which made no sense. But ultimately, that's not what the DC Circuit Court of Appeals held, which actually had ruled against him. So the Department of Justice has been successful against these other challenges, allowing this obstruction of official proceeding charge to continue to be used in cases against insurrectionists. But the reason that's so critical is that's going to be a major charge against Donald Trump for the day of January 6th crime. So remember, 4 categories. 1, day of January 6th, Donald Trump aids and abets an insurrection. 2, the fake electors. Donald Trump, through his agents, has individuals affix their names to fraudulent electoral certificates, claiming Donald Trump won in states where he did not win, sending those to then Vice President Pence on January 6th, where they wanted Pence to count the fake electoral certificates and basically say, oh, looks like these are the right ones, not the ones that were actually certified by the Secretary of State. Looks like Trump won. We're going to have to declare Trump the emperor. That's the fake elector scheme right there. Number 3, wire fraud charges, campaign finance violation, money laundering. This is the conduct by Donald Trump with his various political action arms and even ones that didn't exist. Trump said he was going to have an election defense fund. The election defense fund wasn't even a real thing, and it collected hundreds of millions of dollars. So that's part of Special Counsel Jack Smith's criminal investigation. And then the 4th, Donald Trump's threats made against state and local election officials. And within that category, I also include Trump having aides reach out to local MAGA people who would essentially steal election data from local election offices, like we saw what happened in Coffee County, Georgia, and then in other states where they like literally just stole election data from people and then tried to manipulate the data in declarations to claim that Trump won when he didn't win. So I think Special Counsel Jack Smith has pretty much locked down most of those categories. And now we see him focused a lot on the fake elector part of it. And that's why we see these fake electors from Nevada coming in and they testified before the grand jury. That's why you saw Michael Roman and then Roman's deputy come in as well. Let me give you the last word on this topic, Popok, before we move on to the next one.
Yeah, shout out to the Gen 6 committee because they did a great job in organizing right along the same track that you just outlined. And good to see that Jack Smith is following along in the footprints that was already laid down by the Jan 6 committee, who did a valiant effort to publicize all these things to the American public. Back to Michael Roman for a minute. It's also going to cause a lot of grief and sleepless nights for Boris Epshteyn, because there are plenty of emails that have now been disclosed and are part of the investigation between Michael Roman and his lead person in the Trump world, in the Trump inner circle, Boris Epshteyn, who is the fixer, in-house general counsel, replacement for Michael Cohen. You can call it anything you want, but there's a lot of email traffic between Roman and Boris Epshteyn. So that's going to be a big problem for him. Boris Epstein's phone has already been picked up by the FBI. And although he parades himself around at various criminal hearings for Donald Trump, he himself is either a target or a witness. And we will find out as these indictments that you just outlined roll out. The other the best quote I've seen so far to indicate that people knew that were working in the fake elector scheme, that this was phony, false, and fake, is that there is an email from an Arizona lawyer, Jack Willencheck, where he is going back and forth with Epstein. And he says the following. He says, so we're going to do fake electors, and then these fake elector certificates, someone's going to object in Congress, and then those fake elector votes are going to be counted. And then he later realizes that maybe he shouldn't be writing fake electors. And he says with a smiley emoji, he says to Boris Epstein in another email, let's call them alternate instead of fake electors. But that just shows willfulness, criminal intent, that everybody participating in this scheme, it wasn't us calling it the fake electors. They themselves that were participants in the conspiracy were calling it the fake elector scheme as well.
Wow. I knew where you were going with that quote because I remember reading it, and I was like, yeah, and then at the end of it, he puts the smiley face emoji, and that's where fascism just meets complete and utter idiocracy. We still have some other topics to discuss today, but first, let's take a quick break.
Our next partner is AG1, the daily foundational nutrition supplement that supports whole body health. I drink it literally every day. I gave AG1 a try because I was tired of taking so many supplements, and I wanted a single solution that supports my entire body and covers my nutritional basis every day. I wanted better gut health, a boost in energy, immune system support, and wanted a supplement that actually tastes great. I drink AG in the morning to start my day. It makes me feel unstoppable and ready to take on anything. And on top of it all, I'm doing something good for my body. I'm giving my body the nutrition it craves, and I'm covering my nutritional basis. I've tried a ton of different supplements out there, but this is different, and the ingredients are super high quality. I got started with AG1 because I used to take all these different pills and gummies, who knows what, and frankly, what I was taking was expensive, and I didn't even know if it was good for me. But with AG1, I know what I'm consuming has the best ingredients and also tastes delicious. AG1 makes it easier for you to take the highest quality supplements, period. When I started my AG1 journey, very quickly I noticed that it helps me with improved digestion, energy, and overall, I just feel great. It's just one scoop of powder mixed with water, once a day, making it a seamless and easy daily habit to maintain. I'm asked all the time about the one thing I'd do to take care of my health if I could only pick one. It'd be foundational nutrition, and AG1 is a top foundational nutrition product. Just one daily serving gives me the comprehensive foundational nutrition I need and supports energy, focus, strength, and clarity with 75 high-quality vitamins, probiotics, and whole food-sourced ingredients. I can't think of another daily routine that pays off as well as AG1, which is why I trust the product so much. If you're looking for a simpler, effective investment for your health, try AG1 and get 5 free AG1 travel packs and a free 1-year supply of vitamin D with your first purchase. Go to drinkag1.com/legalaf. That's drinkag1.com/legalaf. Check it out. This podcast is sponsored by Miracle Made Sheets. Whether you want to get more fit, be a better parent, or get more done at work, there is one thing that will help, and that's better sleep. With Miracle Made Sheets, you can tap into the power of self-cooling temperature regulation, which has been shown to improve deep sleep quality by over 20%. Using silver-infused fabrics originally inspired by NASA, Miracle Made Sheets are thermoregulating and designed to keep you at the perfect temperature all night long, so you get better sleep every night. These sheets are infused with silver that prevent up to 99.7% of bacterial growth, leaving them cleaner and fresher 3 times longer than other sheets. No more gross odors. Miracle Sheets are luxuriously comfortable without the high price tag of other luxury brands and feel as nice, if not nicer, than bed sheets used by some 5-star hotels. Stop sleeping on bacteria. Clean sheets mean less bacteria to clog your pores and fewer breakouts and other skin problems. Go to trymiracle.com/legalaf to try Miracle Made Sheets today. And with Mother's and Father's Day right around the corner, this is the perfect way to give someone you love the gift of better and more luxurious sleep. Save over 40% and be sure to use our promo code LEGALAF at checkout to save even more and get 3 free towels. Miracle is so confident in their product, they backed it with a 30-day money-back guarantee. So if you aren't 100% satisfied, you'll get a full refund. Upgrade your sleep with Miracle Made. Go to trymiracle.com/legalaf and use the code LEGALAF to claim your free 3-piece towel set and save over 40% off. Again, that's trymiracle.com/legalaf to treat yourself. Thanks again to Miracle Made for sponsoring this episode.
We are back live.
I'm going to grow the beard back. Now that I see it on those ads, I'm going to grow the beard back, I think.
I mean, I didn't want to say anything because I figured you were reading the comment section, but
right. Like a bald
you've arrived
rat.
at the realization. You've arrived at the realization on your own. We'll just say that.
You mean like what's the one that somebody calls you? Some sort of rat, mole
Oh,
rat?
Okay. I was complimenting you. I was complimenting you, and I was complimenting.
Yeah, we have by the way, we have a lot of back.
There was someone early on. There was someone early on in the early days of the podcast. He knows who he is. Who said that my beard looked like the ass of a naked rat mole or something like that? And then he made his emoji the naked rat mole. But I was just trying to compliment you, Popok, and say that your beard looked good.
No, I appreciate that. We have a lot of products that are inspired by NASA. It's amazing what comes out of the space program.
There's a lot of inspiration right there. And but look, in all seriousness too, we appreciate that our sponsors support this program, to be able to put on these pro-democracy broadcasts, to be able to devote our time to this for researchers, for editors, for the whole operation here. And there's some really great products. And so you could check them out in the description of the YouTube or in the podcast to support our sponsors. And if you want to become a member of our YouTube page, hit that $ below. You can give people memberships. You could get yourself a membership. We don't have outside investors here, and that's how we support this network and grow this network. So that would be appreciated, but no worries at all. If you can't, the best thing you can do is just share and spread these videos and get out the message of truth, democracy, and real law and order. Speaking of law and order, Judge Beryl Howell, federal judge in Washington, D.C., issued a sanctions order against Rudy Giuliani on Friday. I have a little bone to pick with Judge Beryl Howell because she did the sanctions order as a minute order and not on like an ECF document. So the order is like in 3 font and really small and many, many, many paragraphs. So I had to look at it with like...
you are a law nerd.
I had to really kind of look at it with a magnifying glass. Yes. I bought a magnifying glass to look at Judge Beryl Howell's order. But the essential point of the order, look, we've been covering what's been going on here, right? You got Ruby Freeman, Shea Moss, Georgia election workers defamed by Giuliani, Donald Trump, and others who claim that they brought in secret thumb drives, and then Giuliani manipulated this video footage to selectively edit it to be like, you see, they were smuggling in the ballots, and that's not what was happening at all. And then Giuliani and Trump called Ruby Freeman and Shea Moss just horrific names and accused them of being criminals and like drug dealers and like just all these really, really horrible things. So Ruby Freeman and Shea Moss filed a defamation case against Giuliani and the OAN network. OAN settled. They didn't sue Trump probably because, unfortunately, they knew that would just probably cause a lot of headaches just to deal with because Trump was still in office at the time. Was he going to assert an immunity? Was that just going to take a lot? They can still, I guess, potentially reserve the rights to bring him in. But I think they just wanted a clean shot to clear their name and not deal with any of that, which also goes to show you sometimes Trump's harassing litigation tactics, though, how they're weighed by a plaintiff's lawyer who has finite resources. But they've got great lawyers. Shea Moss and Ruby Freeman, who've done a great job here. OAN settled the case. The case remains against Rudy Giuliani. Really since, I think, March, maybe even earlier, February, we've been seeing motions that have been filed by Ruby Freeman and Shea Moss's lawyers alerting the judge, look, we've got fact discovery deadlines that are approaching in May, meaning that the period of time where documents are exchanged and depositions are taken, emails and text messages are produced, third-party subpoenas, that's approaching in May. Judge, looks like Rudy Giuliani's playing games. We want to bring this to your attention. That started in March. Giuliani's like, no, I'm not. I just have to search for it. Then you fast forward by May, they were like, Judge, this deadline's approaching. We told you this is what he was doing. He's a liar. We need these documents immediately. Compel these documents. The judge in May orders Giuliani to show up. Giuliani basically claims that he's broke and says, look, I'm $320,000 in arrears to this discovery vendor called Trust Point. They're the group that took all of my documents after the Department of Justice executed a search warrant. In the various litigations I'm in, I owe them money, so I can't get my documents. I'm too poor to participate in this case. So the judge said, okay, sign a declaration that shows your financial condition. Show us your financial condition. Put it under penalty of perjury and get it in by whatever the date was. And then the date before it was due, Rudy Giuliani said, actually, I found the money. I can pay for it now. So judge, you don't have to worry about me doing that declaration, listing my assets and my financial condition. We are good to go. And then the judge was like, okay, but let me know what's going on, basically, to the parties. And then Ruby Freeman and Shay Moss's lawyers then were like, okay, Judge, he's still not turning over the records. Like, he still is not producing the records. We're basically in the same place we were in March or February when we brought this to your attention. And he's just been playing games. This was all a delay tactic. Issue sanctions against him and compel him to produce all of these records. And you may recall from some of our other hot takes, Giuliani was using the name Helen on emails, and he has this email address like Helen 1234, this other numbers, but Helen, whatever the numbers are, at Gmail. And that's how he would use to communicate. So Freeman and Moss's lawyers were like, look, he didn't search that email account. He didn't search this email account. He's using all these aliases. He's not doing the most basic searches. You compel him to produce that and sanction him. And the court agreed. Judge Beryl Howell, we all know that name, Beryl Howell. She's the judge presiding over this case. She used to be the judge who presided over all of the disputes regarding the criminal grand juries that Special Counsel Jack Smith and frankly anybody, any prosecutor who was presenting evidence before the grand juries in D.C., she would resolve those disputes as the presiding judge. That got the baton got passed to Judge Jeb Boasberg, who's now the presiding judge who makes those decisions. But in federal court, the judges hear both criminal and civil cases, which is different than a lot of state court proceedings where you have just civil judges, criminal judges, family law judges. So Judge Beryl Howell hears criminal cases, civil cases. This is a civil case before her. She ruled in this microscopic order that I needed a magnifying glass for, that Giuliani was going to be monetarily sanctioned, and he had to turn over the records. And now Ruby Freeman and Shay Moss's lawyers need to submit a motion regarding their attorney fees. So now that they've been sanctioned, there is no monetary amount yet. But they will be entitled to get their fees for all of these motions. I'll get your take, Popok. It's going to be a huge amount. I mean, they filed a lot of discovery motions. I would be surprised if the sanctions was under $100,000. I think it'll be close to it. I mean, there were several motions, large law firm doing a lot of work. I would expect hundreds of hours went into these filings.
I think it's going to be like 250. Sounds like a good number, and matches up with some other numbers in the case. For those, Beryl Howell, as we get caught up into the minutia, which is really, really important, of sanctions against Rudy Giuliani, sometimes we lose the forest for the trees. He is going to lose the defamation case brought by Ruby Freeman and Shay Moss. I'm going to say it again. Rudy Giuliani is going to ultimately lose this the way that Fox News had to settle because they were going to lose against Dominion. He is going to lose this. This is why OAN, the once co-defendant, and that right-wing MAGA media network settled with the two of those plaintiffs and paid some undisclosed amount of money in a confidential settlement. Rudy I don't know why he keeps jerking around with this case and doesn't settle it. And how do I know he's going to lose the case? I want to remind people what Beryl Howell wrote in her opinion, her order, when she denied Rudy Giuliani's motion to dismiss the case back about 7 months ago. And in just in this 1.5 paragraphs, you're going to know that he is dead man walking, and why he's continuing to incur and subject himself to penalties and sanctions on top of a future award by a jury against him or by a judge on summary judgment. I have no idea. This is what the judge presiding had to say. The same judge that when she wasn't the chief judge overseeing all grand jury process that you outlined, Ben, was also a working trial judge that handled a lot of Jan 6 sentencing. I mean, she knows this matter and Donald Trump, Rudy Giuliani better than probably anybody in her capacity. And she wrote, this is the beginning of her order. After the polls closed across the country on November 3rd, 2020, the first presidential election in U.S. history to be conducted in the midst of a deadly global pandemic, the results in some states were immediately called, with either former President Biden or then President Trump declared the obvious winner. In other states, including Georgia, the margins of victory were substantially closer, and voters and candidates went to bed that night not knowing who had won. As days passed, local and state election officials, here we go with Ruby Freeman and Shay Moss, diligently conducted the counting of absentee ballots and manual recounts, but the void of clear results became filled with increasingly outlandish paranoia from those claiming the election was being stolen. Defendant Rudolph Giuliani, a current media personality and former politician once dubbed America's mayor, propagated and pushed that false narrative, caught in the crossfire of Giuliani's campaign to undermine the legitimacy of the 2020 election, were plaintiffs Ruby Freeman and Shay Moss. Freeman was a temporary election worker in Fulton County, Georgia, while Moss worked on Fulton County's absentee ballot operation. After Giuliani made a litany of statements and accusations against the plaintiffs concerning their activities as election workers, this suit ensued. He is going to lose this case on summary judgment before it even goes to a jury. The only thing a jury is going to have to ever do is figure out how big of a check to write on Rudy Giuliani's checkbook. But once again, like all of them, Trump, the leader of the world, the army of magical thinkers, they all think something's going to happen. I don't know, an asteroid is going to hit the planet before they get a judgment against them. It's not going to happen. We're going to talk about Jean Carroll next. Donald Trump is going to have to pay more than $5 million to Jean Carroll. He's going to pay $10 million plus for continuing to defame her. Rudy's going to pay Shay Moss and Ruby Freeman whatever he has left in his coffers. He's going to have to go underneath his mattress to find money and go check in the cushions of his couch. He is going to lose this. That he continues to struggle when caught by a cobra, it is just remarkable to me. But it is this insane, delusional theory, this magical thinking theory that animates all of the top leadership around Donald Trump.
And you use that term magical thinking, of course, because that was the exact language, as we all now know, in the brief that was filed by Jean Carroll's lawyers, Roberta Kaplan. And she uses the term sarcastically magical thinking and basically says, because, Donald Trump filed a motion to try to reduce the jury verdict award for $5 million to less, arguing because the jury didn't find that he engaged in a rape, that Trump claimed he won the case. And so when you read this motion that's filed this week by Jean Carroll's lawyers, she goes, this perverse magical thinking where Trump engages in a sexual assault and he's celebrating that as a win. And we really need to think about that for a second, because that's what Donald Trump did. And the fact that there are people who support him, there is a legal filing where Donald Trump is claiming that he won the case, essentially, that was brought by Jean Carroll. And the jury was wrong in awarding monetary damages because Trump is arguing in this an illegal filing. It's Trump's filing It's not like, oh, Ben, you're making this up. It's in a filing where Trump says, because the jury only found that he engaged in and it's not an only, but that's how Trump argues it, sexual assault, he actually won. He's the winner. And, maybe in front of your MAGA rally that makes sense, but in front of judges and logical people, that absolutely is abhorrent. So that's something earlier that was filed in the Jean Carroll case by Roberta Kaplan, Jean Carroll's lawyer. And to your point, Popok, I mean, Trump lost the first trial and then basically doubled, tripled, quadrupled down on the defamation because there are these factual findings that are now being made, that have been made by the jury in this Jean Carroll trial where he lost. There's not a lot to be decided in future cases. And so Jean Carroll and her lawyers could just go in front of the jury and say, you have to stipulate that a sexual assault occurred, that the statements are false and defamatory, and what is the value now that you would place jury? If another jury awarded $5 million, what is it now that he continues to do it and punitive damages are supposed to punish? So to me, Jean Carroll's lawyers, they're already saying at a bare minimum $10 million they're going to ask in future cases against Trump. But I wouldn't be surprised now that they've won the 5, to go and say it's really 50. It's $100 million for this conduct. What could be more despicable and disgusting than a situation where you prevail, you clear your name, and then the very next day your abuser goes on national television in front of 3 million people and then says it again to you the day after you prevailed in trial and cleared your name. He brings you down again like that and defames you again. But tell us about this surety bond situation and what's the latest in that case?
Yeah, and for those that are interested in a little more deep dive, I do a hot take, and so do you, Ben, on the graphic nature of what Donald Trump is trying to allege in order to shave $4 million off of the $5 million jury award. He basically concedes that he got convicted, I would say convicted because it is a crime. That's the basis of the civil case, the crime of sex abuse. The only reason it wasn't rape under New York laws, New York has a unique statute that requires penetration, penis in vagina, for it to be rape, and fingers don't count for rape. They count for sexual abuse. And that's the only reason that the jury found that. It's not something to be proud of. It's not something to say, I got vindicated, I'm only a sex abuser. But that's what Donald Trump is actually now left with, having to argue in order to try to shave $4 million off the top of his of the verdict against him, which he will not prevail. I'll make the prediction now. I'll go out on a limb. There's no way he's getting a new trial in the case related to the statements he made after he was no longer president. And there's no way that is being reduced. The jury had good grounds on each of those points. They went with the numbers that were given to them by the experts. There was only one set of experts that testified in that trial, and that was for Jean Carroll. Donald Trump didn't have one counter expert at all. And yes, it's unusual. It's weird. In fact, the counter expert he had on the economic damages to say that she didn't suffer that got sick the day of the trial and didn't testify. Can't make this stuff up. So that's a loser. And then, as we predicted and said a couple of months ago, that in order to take an appeal, when you have a money judgment that is against you, you can't just say, well, I'll pay that down the road. Let's see what happens. Let's spin the wheel, roll the dice, see what happens in my appeal. I'll get back to you on the money. No. If there's a money judgment against you in every state and federal court, you have to post a bond. It's called a supersedious bond. It's a Latin way of saying we'll keep the judgment on hold until we see what happens on the appeal, but we don't want to have to make the judgment creditor. That's what Jean Carroll is now, a judgment creditor against Donald Trump personally. We don't want to have her have to go chase the money. So if you're going to appeal, you have the right to appeal, but you got to put up the money, 110% of the amount of the judgment. Now, what normal people do that can either get bonds or aren't trying to save $50,000 or $100,000 is they go and get a bond. And they put up assets and they fill out financial forms, and a bonding company it's usually not a bank, it's usually a bonding company, puts up a bond for the amount. Now, there's a premium that you have to pay for as long as the bond is in place. It's normally 1% of the total amount. So if he's got to put up this 5.5 million, which is 110% of the judgment, then the bond is 1% of that, or 55,000. And if the appeal lasts longer than a year, even if it's like a 1 day longer than a year, you got to post the premium again. You don't get it back either. If the appeal lasts 366 days, you're paying 2 premiums, and that would be 110,000. So one of 2 things happened here, Ben. Either Donald Trump is so cheap that rather than get a bond and pay $110,000 and not take his money out of his bank account and tie it up sitting in a court registry, which is where the money's going to end up, he decided to put up 5.5 million cash that'll just sit dead in an account, not interest bearing, with the court clerk, and to save $110,000, which would be a year, a little bit more on premium. Or he can't get a bond and had to put up cash. I don't know which camp I'm in. I think he's trying to save the $110,000. You think that he can't get the bond, right?
Well, I think it's important to know the source of this money, which is something that I wonder if Jean Carroll's lawyers are going to follow up about and basically say, we don't want dirty money. So
well, they haven't objected to the cash being put up.
What'd you say?
They haven't been. Robbie Kaplan, the lawyer, has not objected to the cash being used.
Right. Exactly. But the filing just happened. At the end of last week, and so it's not something that there was a stipulation that was submitted by Trump's lawyer. I don't know what the judge's view is going to be of that. Is the judge going to want to know? I mean, look, the Judge Lewis Kaplan sits in the Southern District of New York. There is a Southern District of New York criminal investigation into the dealings between Trump Media and Digital World Acquisition Company. So like Trump's under criminal investigation through his entities, at least in the Southern District of New York, through the Digital World Acquisition transaction. So Judge Lewis Kaplan knows about that. Judge Lewis Kaplan obviously knows that Special Counsel Jack Smith's investigating Trump for money laundering, wire fraud, and campaign finance violations regarding all of those political action committees. Judge Lewis Kaplan knows that the Trump organization was convicted on 17 felonies last year regarding tax fraud. And so I wonder if Judge Lewis Kaplan will do a variation of what Judge Beryl Howell did and just say, yes, I'm okay with this, but can you let me know what is the money coming from? Personal funds, corporate funds? It'd be interesting, or they may just be like, whatever. At the end of the day, they're posting the bond in the amount of 111%, which is the amount that you're supposed to post.
To be clear, I didn't mean to suggest that we don't know if Robbie Kaplan, for the lawyer for Jean Carroll, is going to object. She's not going to object. She's going to take the cash. But Joe Tacopina had, again, how he is still a lawyer for Donald Trump. Donald Trump bragging at the Jan 6 fundraiser recently that only the best and the brightest, the greatest law firms all want to work for me. That's a lie. Okay. What he's left with is people like Joe Tacopina, who in response to a reporter's question, texted back, like, why are you posting a cash bond? Is it because you can't get a bond? Is that why? And he wrote back a 2-line text that said, this is like caveman lawyer. Bond costs money. He has cash. Okay. Thanks, Joe. Thanks for weighing in on that. I still don't think it answers the question. Could your guy get a bond? Or you got to say he's so miserly. Not only is he trying to, of course, shave off, he should just be happy. He should be happy that he got found to be a sex abuser and the jury only hit him with $5 million because they hit him with a very low punitive damage number. Like you and I and others can't figure out the punitive damage number. It was like $300,000. I thought if they're going to whack him, they're going to whack him on top of the $4 million and $4.7 million in actual damages, we find another $4.7 million in punitives. They didn't. They just, I think the jury said, we're going to give her $5 million and we're going to do it this way. Boom, boom. We're going to round it up. That's going to be punitive damages. He should be happy that's all they did.
Yep.
Instead, he's like, no, let's drive it down to 1 million. That's the most she should. And let me give you a new trial too. And yeah, I'm going to post them. So he's going to take $5.5 million out of whatever account, legal or illegal, or Save America PAC, that could be earning interest or invested somewhere. And he's just going to sit it for a year and a half I think it's because he can't get the bond, but we'll never know. And leave it. And as you said, compliments to Robbie Kaplan. She doesn't care. She just knows if he loses the appeal, she's got a source of cash that she can go after.
Exactly. Yeah. But look, accountability is here. And as I stated earlier in the show, I think we're seeing accountability internationally occur as well. And I think that it certainly is inextricably intertwined, these events, and not just coincidences. Well, it's an honor to spend this time live with you all here on the MeidasTouch Network. We know that you could be anywhere else this evening or whenever you're watching or listening to this, either on the weekend or during the week, but you're here with us. We're so grateful for you. We know none of this is possible without the legal AF community. So thank you from the bottom of both of our hearts. If you want to become a member of this YouTube channel, remember, click the $sign. You can purchase a membership. That's one of the ways to help fund this network. You could gift memberships to other people if you are so inclined. If you'd like to receive a gift, you can make yourself eligible by clicking on the $sign. I believe there's a feature to request a gift, or that you could be a recipient of a gift. Go to store.meidastouch.com for the best pro-democracy gear, the Convict 45 pins, but also the Legal AF official merch. I was walking in a flea market earlier this week, and I saw actually somebody wearing a MeidasTouch shirt, which was a pretty cool thing to see. I did not make a point of it, but it was cool to see. I wasn't sure if I would go up and be like, "Hey, how are you?" But I saw someone wearing it, so it was a pretty cool thing. But send us photos of yourself wearing the MeidasTouch gear, post it on socials, and we love seeing it. We love seeing it. Again, thank you, everybody. Hit subscribe on our YouTube. If you just watch on YouTube, make sure you subscribe as well wherever podcasts are available. You could subscribe on an audio podcast. Just search Legal AF. For those who listen only on audio, subscribe to the MeidasTouch YouTube channel. We're looking to get 1.5 million subscribers on YouTube by this summer, trying to get 2 million subscribers by the end of this year. Let's keep growing this pro-democracy network together. And again, none of this is possible without you. We are so grateful for you all. Popok, love spending this weekend with you. Everybody have a great rest of your weekend, great week, and we'll see you next time on Legal AF. Shout out to the Meidas Mighty.